By the early 1900s, there were some 800 different trial courts in California, operating without any centralization. People complained that courts and justice varied too much from location to location. So in 1926, voters amended the state constitution to create the Judicial Council, to provide leadership for the branch. Today, the Judicial Council is well defined as the policymaking body of the California courts, the largest court system in the nation. Chaired by the Chief Justice, who's elected statewide by the people of California, the Council is responsible for ensuring the consistent, independent, impartial, and accessible administration of justice throughout the state.
It's like a board of directors for a large, complex, public organization.
The California Constitution spells out council membership, 21 voting members, the Chief Justice and one other justice of the Supreme Court, 3 justices of courts of appeal, 10 Superior Court judges, and 2 non-voting court administrators. Each is appointed by the Chief Justice to 3-year terms, 1/3 turnover each year.
This ensures continuity for council. It also creates opportunities for new participation for court leaders statewide.
The State Bar appoints 4 members, and the State Senate and the Assembly each appoint 1 member. The Chief Justice can also appoint additional non-voting advisory members. The nomination process is on the court's website. Chief Justice Tani Kantil-Sakaue strives for diversity in her appointments.
Gender, ethnic, geographic, culture, court size, and legal experience.
There are 5 internal committees of the Council: Executive and Planning, Rules and Projects, Policy Coordination and Liaison, Litigation Management, and Technology. The Administrative Director of the courts serves as Secretary to the Council, a non-voting position, and the Administrative Office of the courts provides staff support to implement the Council's policies. The full Council meets at the call of the Chief Justice no fewer than 4 times a year. There were 8 meetings in 2011, and a record 12 in 2012.
I have little doubt that this body, the Judicial Council and the judicial branch, is the finest judiciary in the nation. It can rise to the challenge, and we can and will put in place the foundation for a new era in California.
Meeting agendas are posted on the court's website at least 7 days in advance. Meeting reports and related materials are linked as soon as they're available. Minutes of each meeting are also archived here. Business meetings are open to the public except when they discuss personnel issues, litigation, security, and other confidential topics. And starting in 2011, the educational pre-meetings have also been open to the public.
The more sunshine, as Justice Brandeis said many years ago, the better.
Public comment is invited and encouraged, either through correspondence or in person. And the audio from meetings is streamed live on the web. The Constitution states that council members do not represent any particular constituency, notwithstanding any of their other affiliations or roles. Rather, each member is responsible for ensuring the consistent, independent, impartial, and accessible administration of justice for all Californians, which leads to sometimes spirited conversations.
Enough is enough. We've really been pushed to the wall.
The conditions there, in my estimation, are deplorable.
Many tough and often untenable choices have to be made, and they have to be made now.
But the vast majority of discussion, investigation, and study is done long before initiatives come to the Council. More than 400 people serve on advisory committees, task forces, and working groups. Judges, justices, lawyers, court executive officers, and experts in their respective fields. Appointed by the Chief Justice, these groups put in countless hours of study and research to advise the Council on court business, improving judicial administration, and assisting the Council in achieving its strategic goals.
They don't serve for the individual purpose of their court. They're picked for those advisory committees because they're looking at statewide proposals that will best serve the public and the courts as well.
For example, the Trial Court Presiding Judges Advisory Committee and the Court Executives Advisory Committee developed and recommended to the Council a program to help trial courts improve productivity, increase efficiencies, and reduce costs.
Clearly, it can make a difference and reduce the impact of the resource cuts that we've had in the last couple of years.
Another new Council initiative, the Liaison Program. The Chief Justice named a small team of Council members to serve as liaisons to each of the 58 courts to open lines of personalized, informal communication.
We are making sure that each trial court has direct access to the Judicial Council.
So if something went wrong or they had a question, they know a face and a name that they could contact over the Judicial Council.
It's an initiative that's representative of the Judicial Council's mission and priorities for the branch.
I think we have many court leaders who care deeply about the future of the courts, and we have much to talk about in the future,
including the continuing goals of maintaining access and fairness, independence and accountability, and high-quality service to the public.